Hi, Dr. Blair. It's great to see you again. Could you please introduce yourself for me?
Great to see you as well, Dr. Green. Hello, everyone. My name is Monica Kristin Blair, and I am a historian of race and education working here at Johns Hopkins University. So coming to you from Baltimore.
And I'll introduce myself as well. My name is Preston Green. I am the John and Maria Neag Professor of Urban Education, also Professor of Educational Leadership and Law at University of Connecticut. And a lot of my research focuses on legal issues in education and school choice. And not surprisingly, religion is taking a great deal of my time right now, given what's going on at the moment. So, Monica, let's start. You're writing a book on the history of school privatization, which is really timely. And can you give us some basic background history on the intersection of race, religion, and education?
Yeah, I'd be happy to. So today, when we think of private religious schools, we're often thinking, because of how it's portrayed in the media, about predominantly white religious schools. The Trump administration obviously put a lot of emphasis on funding religious education as well, which sort of solidified those ideas. But a lot of early Black education was actually through religious and church-based schools. And that's because the state had really failed to provide educational opportunities to Black children in the 19th century. And so it was often mission-driven or religious schools that stepped in to fill this gap, particularly immediately post-emancipation. And so it's really another reason that we start to sort of associate that religious schooling with whiteness is because of the rise of religious segregation academies in the wake of Brown v. Board of Education. So everyone knows the case Brown, but one thing that people often forget about it is that Brown v. Board of Education only pertained to public schools. It didn't say a thing about segregation in the private sphere. Because of that loophole, a lot of white supremacist politicians and parents tried to create private schools to get around the desegregation mandate that came from Brown. And states also came into play in funding those opportunities. So a lot of the Southern states would pass things like tuition vouchers and subsidies for teacher salaries in these schools. They also transferred public physical materials to these schools, giving away things like textbooks, selling them old school buildings at a cheap rate. And so you see that really rise of white religious schooling in reaction to Brown, where religion can kind of be a shield so that they can get away from some of this scrutiny of the racism inherent in that movement. And this led to a lot of debates over the sort of fate of vouchers in the 1970s and 80s. But you see these two sort of trends are in tension then, right? So on the one hand, you have white conservatives seeking to sort of own religion and religious freedom in the educational space and using it as a sort of ostensibly colorblind means of promoting white supremacy and lost cause narratives. But at the same time, you do have a long history of Black communities who are interested in religious schooling and have found value in that space.
As I said, I teach educational law, and one thing I like to say when I get into this issue about the landscape now legally is that everything is on the table. So, people were, surprised just last year, just recently when the Supreme Court ruled in the affirmative action case, SFFA versus Harvard, that, race can no longer be used in admissions, overthrowing like 50 years of legal precedent. And I just want to use that just to say that that's just one area where we're seeing really major changes. And that's certainly happening with respect to religion and education. And I think that what you have to understand is that the Supreme Court has been engaged in a very long-term really effort to kind of emphasize or strengthen the establishment clause the free exercise clause at the expense of the establishment clause. So let me tell you what those two clauses are about. They're both found in the First Amendment, and the establishment clause prevents the government from establishing a religion. And I'll just say that there's a long-standing case, that Lemon versus Kurtzman, which I'll talk about later, which kind of defined really kind of how we determine what establishment would mean, looking at whether or not the government action was for a secular purpose. Did it advance or inhibit religion? And did it have be an excessive entanglement between government and religion. The free exercise clause, in contrast, was designed to protect the rights of individuals to practice religion as they so desired. And so what the Supreme Court did very recently in terms of strengthening the free exercise clause in relation to the establishment clause was that very recently it weakened what are called Blaine amendments. And Blaine amendments are state constitutional provisions that have greater restrictions on spending for religious activities. They're greater usually than the Establishment Clause. And what the Supreme Court did in a few recent cases was to say that those provisions could not be used as an excuse to prevent funding for religious education. So for example, in Espinoza versus Montana Department of Revenue, the Supreme Court found in 2020 that you cannot have a school choice program, private school choice program that excluded religiously affiliated institutions. And then 2 years later in Carson versus Macon, the Supreme Court also then found that that religious institutions could not be excluded from private school choice programs if they were going to actually overtly teach religion. So we have really in a few cases a situation where religious institutions must basically be included in private school choice programs. Now, we're in a new phase right now, which is happening, which is that now proponents of expansive religious liberty are focused now on charter schools. And people are always surprised when they hear that charter schools are the next frontier. And that is because charter schools are ostensibly defined as public schools under state statutes. And so people think, well, wait a second, if they're defined as public schools, then these schools cannot be religious, right? This is a clear violation of the Establishment Clause, not so fast. And the reason for this concern is that, charter schools, even though they're defined as public schools, they have many attributes that are like private schools. Most notably, they are operated by private appointed boards rather than publicly appointed school boards. And so those folks who want to have religious charter schools say that, no, these charter schools are really like private schools. And so Carson versus Macon is applicable in that religious entities cannot be excluded from charter school programming, and they cannot be prevented from operating religious charter schools. And this past year ago, an Oklahoma charter school board used this logic to approve a religious online charter school that will be operated by 2 Catholic dioceses in Oklahoma. And the Oklahoma Supreme Court recently heard a case about this, where plaintiffs are saying that the funding of the operation of these religious schools is illegal. And we're all thinking that this case or another case like it is going to go to the U.S. Supreme Court very soon. And there's a very good chance that the Supreme Court would find that these charter schools must be allowed to operate. Now, there's a big question, and certainly in Democratic circles, and certainly in progressive Democratic circles, about what to do about this. And so they're really fighting funding of voucher programs, and they're really fighting the idea of religious charter schools. And they're thinking that, they're assuming that really let's say all Democrats believe this, but I don't think that's really the case. And, Monica, you talked a little bit about some of the history behind, the connection between Blacks and religion and education. But I also want to add a recent 2022 poll from Deseret News and the Marist poll. And what they found was that almost half of Black people who responded to this poll go to church at least once a week, and 2/3 pray every day. And that 3/4 believe in a God that was, as defined in the Bible. And I just point this out to say that there may be this sort of acceptance or approval of this idea in ways that may diverge from other people who may be against it.
Yeah, no, I think that makes a lot of sense and really makes me think back to, as the historian, the debates over parochial aid and sending money to private schools that happened in the 1970s. So one of the things when we think about funding of these private educations is I have a chapter in my book that's about a parochial aid bill that happened in 1970 in the state of Michigan. And so 1970 is an important year in Michigan history because this is also when the NAACP is suing the city of Detroit to force them to desegregate their schools. So school desegregation is moving outside the South and moving west and moving north to other states that also very much had segregated school systems. And it's at this precise moment that private school advocates were trying to push forward this parochial aid bill, which did ultimately pass in the Michigan state legislature, that provided subsidies to help pay for teacher salaries in private schools. The problem with this was that 98% of the private schooling marketplace, 98% of the students in those schools were white in the state of Michigan. And so a lot of civil rights activists opposed this bill because they saw it as taking money out that could go to those public schools, these especially underfunded Black schools in the city of Detroit, and giving it to this overwhelmingly white sphere of private education. And so you have this alliance of civil rights activists, teachers, union organizers coming together to pass a referendum that made it illegal in Michigan for them to give public money to private institutions and private religious institutions, since most of these schools were Catholic schools. And so you had a lot of civil rights activists involved in that fight. The NAACP was on the side of overturning parochial aid and keeping this separation firm between public funding and private education. But you also did have some Black families that were in favor of that bill. Particularly the Black students who were enrolled in private schools were mostly enrolled in religious, majority Black private schools in the city of Detroit. And there was, a predominantly Black Catholic school. There were also a few Black Protestant schools. And then you also had the Nation of Islam operated its parochial schooling in Detroit as well. And so especially some of those Black Catholics were really advocating for this parochial aid bill because they were facing the threat of closure because a lot of Catholic schools were closing across the nation in 1970. And so they saw this as a way to kind of help keep them afloat. And so you did have the majority of these Black civil rights activists were against the bill, and ultimately they won that grassroots fight. But you did also have this, meaningful minority of Black families who were interested in public funding for religious education. And I think that's kind of a small microcosm of what is a broader trend that you saw in the 1970s and over these fights over publicly funding private education. And there were a lot of different ways you could publicly fund private education, and that's still true today. There's a lot of talk about vouchers, right, which is where the money follows the child to the school of their choice. One of the problems with vouchers is often that there's a cap on how much how much money that includes, and it's often not enough to fully fund education in these private schools. So then you can have it ultimately go to middle-class families that might have put their kid in private school anyway, because there's not actually enough to cover it for a low-income family. But there's also things like subsidies for teacher salaries. You can also have grant programs that go towards things like textbooks or school buses. There was already a private school bus bill that gave public money for that in Michigan prior to parochial aid. And then, of course, there's the charter question, right, which those didn't exist in the 1970s yet, but in the 1990s really blurred this line between what is a public school and what is a private school. And one of the things I argue in my book is that privatization advocates have really tried to blur that line between public and private in ways that allow for a free flow of money from the public space into private schools, but keep private schools safe from any kind of regulation, including civil rights regulations, but also regulations over things like religion or Can LGBTQ students attend those schools? And so charter schools are just kind of the latest for this iteration, I think, of this blurring. So it really makes sense to me as well that that is, kind of the next frontier where this movement is going. And this is a real reversal because, in 1968, you had Lemon. Lemon was a lifelong member of the ACLU and the NAACP, and he feared that funneling public money to private schools would erode the quality of public education, especially for Black children. And as a father himself of a child enrolled in the Pennsylvania public schools, he was interested in being the lead plaintiff for Lemon v. Kurtzman. So Alton Lemon was one of these activists who challenged providing religious schools with funding for teacher salaries and textbooks in the state of Pennsylvania. And Lemon's case went to the Supreme Court, where Chief Justice Warren Burger argued that this actually violated Pennsylvania law because the First Amendment had a prohibition on the government establishment of religion. And he thought that funding things like teacher salaries is the government funding religion because the whole point of religious education is to teach religious principles in the classroom. But Lemon didn't fully close off public funding for these private institutions. It just said it has to be secular. So instruction is always going to have a religious element in a religious school, but something like you want to repave the parking lot, or you want to build a playground, or you want to pay for a school bus, that was totally okay, according to the Lemon test, because those are secular purposes. But of course, we know a lot of that has changed in the contemporary landscape, right? Lemon is no longer the standard that the modern Supreme Court is following. And so I've talked a little bit about the kind of funding and these like civil rights fights over how we should think about funding private religious schools. But a lot of this was sort of embedded in implicit or like supposedly colorblind racism, right? It's just funding private schools. It's not really making explicit that 98% of those schools were white in Michigan. But what about some of the history of explicit racism in these spaces? How have there been attempts to harness religious liberty protections to openly exclude Black students from religious schools?
Well, that's a great, it is certainly a long history. And as you said before, that Brown versus Board of Education only dealt with public schools. But after Brown v. Board, there was part of massive resistance. And one of the strategies with massive resistance was to provide funding for private schools and schools and these private schools, of course, would then discriminate on the basis of race, and they would not allow Black kids into these schools. And the Supreme Court, and so finally the Supreme Court really first addressed this question in a 1976 case called Runyon versus McCrary. Now, in that case, the Supreme Court ruled that secular private schools cannot prevent Black kids from attending those schools. And they cited a statute called 42 USC Section 1981, which provides in pertinent part, and I'm going to read this: all persons within the jurisdiction of the United States shall have the same right in every state to make and enforce contracts as is enjoyed by white citizens. So the court found that this prohibition about Black students attending secular private schools violated that statute. However, the court did not address the question of religious schools and left open the possibility that religious school, it just said very clearly that they're only dealing with secular schools and not addressing the question of whether or not religious schools could exclude students because of religious belief. But 6 years after the Runyon case, the Supreme Court really kind of limited the possibility of overt exclusion in the case called Bob Jones University versus United States. Bob Jones University was an institution of higher education dedicated to fundamental Christian beliefs, including prohibitions against interracial dating and marriage. And any student caught violating these policies could be expelled from Bob Jones University. Bob Jones University challenged an IRS policy that prohibited institutions that engaged in racial discrimination from receiving tax-exempt status. And in the Bob Jones case, the court ruled that the Internal Revenue Service could prohibit private schools that had racially discriminatory practices from receiving tax-exempt status. And then the court went on to say that the court found that there was no free exercise clause violation as because eradicating discrimination was seen as a compelling governmental interest for the Internal Revenue Service and for the federal government. So the court upheld the IRS prevention of tax-exempt status. It's important to understand that this was not an extreme statement of saying that schools could not discriminate. They could do so. Religious schools could do so if they decided they didn't want tax-exempt status. And most schools decided that they were not going to do that because it just wasn't really, worth it for them. But so that's kind of like the state of play. But as I said before, everything is on the table. And very recently in 2023, in a case titled 303 Creative versus Elenis, the Supreme Court actually suggested that both Runyon and Bob Jones University might be on shaky ground. So in that case, the court ruled that the state of Colorado could not enforce a state anti-discriminatory law against a Christian website designer. And that, the court said that was a violation of their First Amendment free speech rights. So Justice Sotomayor wrote a long dissent arguing that the U.S. Constitution contains no right to refuse a disfavored group. And she also said that the court wrongly declares that a particular kind of business, though open to the public, has a constitutional right to refuse to serve members of a protected class. And then she in a footnote, focuses on the Runyon case and raises real concerns for people who are concerned about the possibility that Black students may eventually, where the court may uphold discrimination by these on the basis of religion or on the basis of speech, for that matter. And she goes, and I quote, "The potential implications of the court's logic are deeply troubling. Would Runyon v. McCrary have come out differently if the schools had argued that accepting Black children would have required them to create original speech like lessons, report cards, or diplomas that they deeply objected to?" This is really concerning because, many of these organizations do believe, and I think they truly believe, that having Black students in their schools would violate their religious beliefs. And is it possible, let's say, that the Supreme Court may eventually find, under this logic of the Elenis case, that that the state cannot impose the requirement that they, let's say, admit students they admit Black students because it just violates their religious beliefs. And under the same logic, it's possible that the Supreme Court could find that having policies that sort of nudge them as in the Bob Jones case to not act in a certain way might violate their free speech rights. So I do think that is very, very concerning. There have been, and I should also note that in addition to the Runyon case and the Bob Jones case, that there may be the possibility that religious institutions could assert religious exemption doctrines to justify the exclusion of Black students. So religious exemptions authorize religious institutions to be excluded from laws that infringe upon their religious beliefs. So a well-known example of this is the ministerial exception. And indeed, in the recent Supreme Court case, Our Lady of Guadalupe School versus Morrissey Baru, the U.S. Supreme Court found that federal anti-discrimination law did not apply to teachers providing religious instructions at religious schools, citing the ministerial exception. Now, while while the ministerial exception applies to employment, there's been only one case to my knowledge that has applied the religious exemptions to students. And there's a Texas trial court case called Beans versus Trinity Episcopal School, in which the trial court dismissed a lawsuit accusing a religious school of failing to protect a student from racial harassment. So the court agreed with the school's argument that, and I'm citing something they called the religious abstention doctrine that barred the plaintiff's claims. And the religious abstention doctrine provides that states cannot get involved in the internal matters involving church governance and doctrine. This is very concerning if this could be used, if doctrines such as this can be used in other cases involving religious private schools. And so this is something that I do find very concerning and something that I do not hope does continue. So as I'm thinking about this, we talked about private schools. Let's pivot to public schools. And I know, Monica, that you're focusing on private schools, but what's the landscape with respect to public schools? Are there instances where race and religion are impacting public school curricula?
Yeah, there absolutely are. There's a long history here of debates about how we teach children in public education and what's on the table and which groups are really centered in curriculums. And that's been a subject of a lot of civil rights activism to try to get things like Black studies into public school curriculum. And there's also been a lot of activism in history of white supremacist groups or white advocacy groups trying to keep it out of the schools. So listeners have likely heard about the kind of modern iteration of this, which is state governments that are placing restrictions on teaching topics related to race. So for example, I grew up in Florida. Florida Governor Ron DeSantis has now banned AP African American Studies courses in Florida public schools. Which is just astounding that that's kind of the landscape we're living in 2024, that you can't teach African American studies in a public school in Florida and several other states as well. Actually, one of my close childhood friends is a public school teacher in Pinellas County, and she's facing the reality of a lot of these book bans as a high school English teacher. And parents, conservative activists who don't even have a child in the public school classroom can petition to remove books from the library. And she told me when she goes in, you seal the holes on the shelves, right, of all the books that have been taken down, often at the behest of a single parent who in this district, or a single person who's not even a parent, that then is affecting the education of every child who attends that school.
And I think about this as well because I write a lot about I write a lot about sort of like the history of race in funding and discrimination. And I'm finding that a lot of the things, a good friend of mine, Bruce Baker, who's a professor at Miami University, and I write a lot about these issues. And we joke that we probably can't, a lot of things that we write about, or a lot of our articles probably couldn't be covered in some of these courses. They would not actually be, part of the curriculum, and they could actually be banned. So, you can certainly see this with, with the CRT bans across this. And there's a personal aspect to this as well, because just a few days ago in my state of origin, Virginia, just turns out that the Washington Post just revealed that the Department of Education had requested or proposal that there be a number of changes to the curriculum in which where mentions of overt systemic racism, for instance, would be taken out, or the use of the word racism would be changed for discrimination. So we're just seeing these examples of refusal to restrictions against telling what's really happening, again, because of concerns and frankly, religious conservative concerns that these things should not be taught.
Yeah, it's absolutely heartbreaking. And it means that a lot of students aren't going to learn their own history in public schools in America. And, I think about the implications for Florida. I mean, the high school that me and my friend graduated from, Gibbs High School, was the first Black high school in the county I grew up in, Pinellas County. It's obviously integrated now. But then now you're going to have what was a historically Black high school that can't offer African American studies and is going to have the kinds of history that they're teaching in the public school classroom, really doing a disservice to Black history and to do Black students in that school building. And it's really a shame that there is this kind of movement and that this has been allowed, and that we have sort of moved backwards in this way when it comes to education for our children in 2024.
And we also have, the other wild thing about this is that now we have these mechanisms that can, can they just sort of like move this not in just traditional public schools, but also into charter schools.
Mm-hmm.
We just talked about how charter schools may actually be, even though they're public schools, they may be private for constitutional purposes, but you're still going to have this really like delivery mechanism of religious charter schools that are just having these curricula that may not teach about what actually happened in this country with respect to race, again, because of these conservative religious concerns. So that is really, really concerning to me as well.
Mm-hmm. And then it makes teaching more difficult, right? I teach undergraduates at Johns Hopkins, and they come from all over the country and, in fact, all over the world. And then if you have some states that are making some of these materials illegal, right? Banning some of these books. And then you have other more blue states like New York that might be putting them into the mainstream curriculum. Students are going to come in with really different views of the world and really different views of this country and its history. And they're just not going to have the same baseline. And that is just a real shame for the students. And it does make teaching more difficult when we don't have some of these shared common foundations.
And there's a chilling effect too for teachers. I mean,
Mm-hmm.
if I teach education law, and I have teachers talking to me very concerned about like what can they teach in the classroom
Yeah.
given these restrictions. And and I tell them, you really do have to be very careful because I mean,
Mm-hmm.
it's a case called Garcetti versus Sabalos, for instance, that says that speech that like basically speech that is part of your like employment responsibility or your actual employment responsibility may not be protected by the First Amendment. And so that certainly could cover in classroom discussions. So, so like talking about these issues could result in a teacher being fired without possible protections under the First Amendment. Now, there are challenges being made right now, widespread, challenges being made saying that they may be unconstitutional for a variety of reasons, and they may actually prevail. But in the meantime, teachers are wondering, like, what about my job right
Mm-hmm.
now? What can I do right now? And so they're going to be very careful about what they can say and what they cannot say, which may in the end be the goal of these
Mm-hmm.
provisions.
Yeah, that chilling effect, right? You could literally be fired, but you also might self-censor yourself to prevent being fired. And even if you can sue to try to get your job back, I mean, being the plaintiff in a lawsuit like that is a terrible experience, right? You're still fired in the meantime. There could be tremendous press coverage. It disrupts your entire life. And not a lot of teachers are simply not going to want to take that chance. And it makes me think historically back to one of my graduate school advisors, Derek Ulrich, is also a historian of education. And he studies teachers during the civil rights movement and does a lot of oral histories with them. And one of the themes you find in there is a lot of those teachers were activists, but they had to be kind of covert activists, right? Because it was white school boards who employed them. And if they were too open and loud, they might get fired. And so oftentimes they had to do more kind of subtle activism in the classroom, encouraging their students to be the ones out there because they could lose their job. That's not every teacher, there's different tactics, but I could see a kind of return to that, the kind of need to be sort of like covert and undercover about your support for some of these racial justice causes. And it's just really a shame that in 2024, that's the place we're at.
And it's back to the future, right? And
Mm-hmm.
and of course, as a fellow one Southerner to another, it's like, was it Faulkner's quote that the the past is not dead, it's not even past.
And there is, in fact, a long history of laws prohibiting the teaching of anti-racist texts in public school classrooms. So one example is the United Confederate Veterans and the United Daughters of the Confederacy actually worked together after the Civil War to ban textbooks from the South that did not conform to lost cause narratives about slavery in the Civil War. So lost cause narratives generally portrayed slavery as being good for Black people and not a fundamental sin against humanity. And they also often justified the Civil War as kind of the war of Northern aggression, and it was really the Northerners' fault, and the Southerners were heroic in that effort. And they were actually working on banning textbooks that cut against this narrative in any way. And they lobbied state legislatures in states like North Carolina to get this on the books and to get created commissions that would pick textbooks for states. And then the UDC would lobby state legislatures to make sure it was a pro-South and anti-Black text that was going into public school classrooms, including Black public school classrooms as well. And so there's this long history here. And in fact, we sort of think of that as, highlighted some of the activism in the South, but textbook manufacturers didn't want to incur the costs of publishing two different copies of the same book. So ultimately what happens is over time, a lot of these textbook manufacturers just conform to that lost cause narrative and also sell it to Northern schools and schools in the West. So even if you're in a state like Connecticut, you still might be getting a textbook that was written to conform to the wishes of these white organizations like the UDC. And so there is this long history here of groups trying to keep any kind of Black history or anti-racist text out of public school education. And likewise, there have been a lot of debates about the role of religion in the public school classroom. One of the reasons we have some of these 1960s cases is because of this long history of religious instruction in common schools. So the common school movement happens in the 19th century. This is reformers who are trying to get free public education available to all Americans as part of kind of citizenship training and creating a good moral American. They define morality in terms of religion, and often in common schools, they would teach a kind of generalized Protestantism. And they're viewing it as like, oh, it's not specifically religion because it's not like specifically Lutheran or specifically Methodist. But you might have readings of, for instance, the King James Bible, which is a Protestant Bible. And so you had Catholic families, especially, and other groups as well. That's one of the reasons they want to create a parochial private schooling system, is because they don't see that as non-religious, right? Because that's not their version of the Bible. That's not the same interpretations of the text. Even within Christianity, there's plenty of divisions about how to read that book. And so let alone when you think about Jewish parents and atheist parents and other groups that increase in the 20th century with immigration from other parts of the world. And so that is exactly why you have this movement in the 1960s to try to reduce that like overt establishment of religion in the public school classroom. And so it was in 1963 that the Supreme Court ruled in Abington School District v. Schwemp that legally schools could not mandate Bible reading and prayer because that was a violation of the Establishment Clause, right? Public schools are an arm of the government. And so if you have government officials, teachers, administrators, forcing students to read from the King James Bible or forcing them to engage in a Christian prayer, that is a state establishment of religion. Now, it's very important to remind people that, individual students and teachers can absolutely still pray and practice their religion in that space. It doesn't say anything about an individual student or teacher's right to pray. The issue is when teachers or administrators are forcing students or sort of leading students in a particular denominational prayer in a way that then is guiding them towards a particular religion. And that, I think, really brings us to the present and the ways in which this is being totally remade by the modern Supreme Court.
It's great that you bring up a lot of those issues about, this history. We talked a little bit about charter schools and about how we may soon have religious charter schools. There are a number of organizations that are religious Christian colleges. Let's say, for instance, Hillsdale College, that are teaching classical education, that are really looking for the possibility of being able to just teach religion through religious charter schools. And they're just, in my opinion, just waiting for the go-ahead from the Supreme Court to do just that. So we may have a situation in the near future where there could be religious charter school chains teaching religiously conservative views about the role of race in this country.
Oh, I absolutely think that is a kind of logical next step for them in terms of getting access to public funding, right? Decades of this movement to get things like vouchers and tax exemptions shifted some public dollars to those private spaces, but not anything to the degree that a reclassification as a charter school would. That would be an incredible infusion of public dollars into these spaces. So I absolutely could see a future where some of these folks are advocating for that.
One case that I want to talk about is Kennedy versus Bremerton School District. And in this 2022 case, the Supreme Court ruled that a school district violated the free exercise clause by disciplining a public school coach for praying after games in view of his players. Now, Joe Kennedy was an assistant football coach who prayed after football games, and he would take a knee at the 50-yard line to offer a quiet prayer. But soon this prayer was then joined by a number of football players, both on his team and other teams. And so he insisted on doing this activity, even though the school district said that he should not do so.
And certainly when you see the footage of all those players huddled around him on the 50-yard line, it doesn't feel very individual to me. I don't know, what about you?
It was silent prayer. So the court first found that the school forbade the prayer because of its religious nature. So therefore, the court ruled that Kennedy would prevail unless the school district could satisfy strict scrutiny to justify its restriction of this prayer. So strict scrutiny required the school district to show that his action satisfied a compelling governmental interest and was narrowly tailored to that interest. So the school district asserted that his action was warranted because it was trying to avoid an Establishment Clause violation. So first, it claimed that it had to act because of his action would violate Lemon versus Kurtzman. And the famous Lemon test requires an examination of whether the government action had a secular purpose, advances or inhibits religion, or creates an excessive entanglement with religion. The district also claimed that it would violate the endorsement test because a reasonable observer might conclude that the district was supporting religion. In other words, someone out on the street will look up at the district's actions and think, oh yeah, the school really is supporting religion and wants this to happen. And finally, the district claimed that that it had to avoid a violation because of what is known as the coercion test. And what the district was concerned about was that certain students would feel compelled to actually have to pray, based upon the coach's actions. The court rejected all of these arguments. And one thing that's really important about this case is that the court abandoned the Lemon test and as well as the endorsement test offshoot. And understand that there was like 50 years of jurisprudence based upon the Lemon test. But the court found that, that the Lemon test was an abstract and ahistorical approach to analyzing the Establishment Clause. So instead, the court established a new rule. And this new rule would interpret the Establishment Clause based on the historical practices and understandings. So going forward, the court said that we were going to look at really what was happening, at the dawn of the Republic, with respect to religious practices and what was happening in schools at that time. And finally, the court rejected the district's coercion argument because they were saying that there was no evidence that students would feel coerced to pray with the coach. They said there was actually no evidence. There were some students who felt that they did have to pray, but the court dismissed that. And also, I will say that, people are, coercion is very, very, people are not going to say that they are coerced. They're going to be very quiet about this and say that, hey, they're just going to really kind of change their behavior accordingly. So the coercion test was, the court created a really high wall, really, as to what would amount to coercion. So, this case again is really significant because Monica you talked a lot about the Shemp case, for instance, saying that, the cases, the Supreme Court has said that school prayer was unconstitutional. It was a violation of the Establishment Clause. And also, like in 1980, the court ruled in case called Stone versus Graham that the posting of the Ten Commandments also violated the Establishment Clause. Again, citing the religious purpose of this act, religious purpose of the posting of the Ten Commandments. But understand that the Bremerton case sent a signal to states that want to engage in prayer and post the Ten Commandments that this may now be allowed. And indeed, just a few days ago, the state of Louisiana just passed the first law in the country requiring the posting of the Ten Commandments in every classroom. And it's clear that the state acted in this manner because of the Supreme Court's Bremerton School District decision. Now, there have been, some discussion about like what the impact of overturning Vitale and Shemp would have in the classroom. And, I do think that this would have a coercive effect on people who don't, particularly subscribe to a certain Christian belief, right? There's definitely different versions of the Ten Commandments that could be posted, and you could end up offending those persons who don't subscribe to that version of the Ten Commandments, or for that matter, persons who believe in other religions or who are atheist and agnostic. So that's, very, very concerning. But I want to add some nuance to this that I'm not so clear that let's say in the Black community, that there may be some differences of opinion. I could see civil rights organizations certainly opposing this, as you discussed with respect to the Procreate decision and how civil rights organizations really did not agree, with what was happening. So I think that you could see civil rights organizations being against this, but you could also see a lot of people in the Black community actually supporting this. Recall the poll that I had mentioned, noting that a high number of Black Americans believed in the God described in the Bible. So I could see that in community, and also understand that our public school system is also very segregated. So I could see that in a lot of Black communities where you have schools with high concentrations of of Christians who believe in the biblical form of Christianity. I think that you could see that many people in those communities would support this. And so it will be very interesting going forward as, thinking about like how we're going to see how this is going to play out.
Yeah, I'm really interested in this too because, coercion is obviously an incredibly high bar. And it'll be interesting to see how the Supreme Court thinks about coercion when it's applied to different religious groups, right? Because in this case, we have a Christian coach leading groups in prayer. Christianity is the most common religion in America and practiced by, the majority of Supreme Court justices. And so there's this issue here of, well, how would the Supreme Court have responded if, for instance, that was a Muslim coach leading students in Muslim daily prayer? My suspicion is that they might think about that differently. And my suspicion is based in part on the fact that many of these conservative states have passed anti-Sharia law, which is a very performative Islamophobic kind of doctrine that they're putting into state law. And so how can you have, are they going to have the same kind of protections for teachers who are leading folks in prayer that isn't Christian prayer? I have big questions about that. And so I think that gets to what Lemon was sort of trying to preserve, right? Was trying to preserve individuals' rights to practice any religion in the classroom or no religion in the classroom, but try to prevent this kind of the state leading students towards a particular religion. I suspect that the Supreme Court might have been particularly okay with it because it was a Christian coach.
Right. I think that's a great point those are great points to put out that you raised. I think that there certainly is this wondering about what would happen if you had a different religion, and I do suspect that there are certainly scholars who are trying to find a way to make this distinction between Christianity and other forms of religion. So stay tuned on that. I also wonder, though, that I think that there are some people who are taking the calculated risk that in a lot of these communities, in a lot of communities where you have people of different religions in these traditional like school districts that were in these school districts where the majority are, let's say, are conservative Christians, that they may be very quiet, that they may not want to broadcast their objections to this because of this subtle coercion, that they don't want to feel that they don't want to stand out, that they don't want to have to say anything. And so this sort of gravity of peer pressure might cause a lot of people to not talk about this. And I bring this up because in my school law courses over the years, I used to teach. I'm a Southerner, as you are, and I teach courses. I used to talk about prayer at football games, right? Prayer at football games, and the Supreme Court did place a lot of restrictions about prayer and football games, as long as it was not like the school directed. But in a lot of states, that still was going on. That still would go on. And I taught a lot of people I taught at Central Pennsylvania, Penn State for many years. And I had students coming up to me saying, yeah, I know, Dr. Green, that this case was there, but this is still happening. And I think, again, it's still happening because people will still do what they will wish to do until there is some overt challenge. And so I just point that out to say that there may be banking on this sort of gravity, this peer pressure to guarantee that, very few people are going to actually challenge these prayers because of the fear of possible repercussions.
Yeah, absolutely. There's the law and then there's the enforcement of the law, right? And then there's practice. And absolutely, I can speak from experience also that certainly there was plenty of religion, and usually Christian religion, growing up in the South for me as well. And so it will be interesting to kind of see when that gets challenged and when it doesn't. And I think that might lead to that point that you're like, some of these folks who are in minority religions might have a reason to be quiet because they'd be more likely to be the subject of a lawsuit than some of these people who are in the majority religion for whatever community they're in.
I think that's a great point for us to think about our final question then, which is like, what is our hope for, what is our things for the future of religious liberty? Now we have like uh, a lot of diversity of beliefs here that certainly have come out in our discussion. What do we think will happen with respect to religious liberty, given the major changes that are occurring, both legally and also in actual practice?
Yeah, it's a big question, and I think that my hopes are different than my expectations in this current political moment, unfortunately. But in terms of my hopes, what I would love to see is a real, true religious pluralism in America. And I'm not sure that we've ever had a moment that fully nailed that basic tenet that we do try to support in this country. I would love to see a world in which, whatever your religion, Muslim, Christian, Buddhist, Hindu, that you feel supported and safe to practice that individual faith in your life and make individual choices. And my hope for that would then be that those individuals feel the freedom to make those choices without impositions from government, from schools, from employers on those practices, right? Right now, the way a lot of these religious exemptions work is often businesses have this right to say, no, I don't need to provide contraception, or no, I don't need to fund abortion because it's against the religion of this group like Hobby Lobby. But an individual who works for Hobby Lobby might not share those same beliefs, and they don't always have the same rights to equal healthcare in that space, for instance. And the same can be true for, teachers at Catholic schools. And so what I really would value and would hope for is a religious pluralism that really protects the rights of every individual to practice their religion in any way that feels meaningful to them, but that also they won't be subject to regulations from either government bodies or private bodies about those religious practices. And unfortunately, I feel like that's often how the law works currently in America. What about you, Preston? What are your hopes for religious liberty in America?
Well, my hopes, and I've been thinking about this question in the context of the major changes that are happening in our educational system. I do believe that our educational system is up for major changes in the next few years, given where the Supreme Court is headed and barring some major unforeseen changes. And so I do think that we're going to have a situation where we're going to have prayer in public school. We're going to have more religious activity in public school, and we're going to have a large number, many more like private schools and charter schools that are religious. So we're going to have a great deal more of an interaction between religion and education. So that I think is going to happen. So in that space, what I do hope, similarly to you, is that there is this religious pluralism on the part of the students choosing. And that is that what is going to happen, as you said, is that it's the entities that are operating that are the ones making that choice. They are the ones with the religious liberty as to who can be in and who can be out. And what I would like to see is one where individuals can go to the school that they wish based upon what they want to achieve within that school. So you certainly are seeing examples of, I mean, in Florida and some of these other places where there have been some controversy about voucher programs who did have LGBTQ students wanting to attend a specific school that did not want them, in part because they had great athletic programming. There was some other reason for this. I even mentioned this, I can even talk about this in terms of my own family experience. My mother attended school during the massive resistance era in Northern Virginia, and actually attended, and so there were actually like public schools were not desegregated until the mid 1960s. And but there was a period during that period where she actually attended Catholic school, and she attended Catholic school, and she was Lutheran. And the mother superiors were every now and then let it be known that, maybe she might want to consider changing religions. But my grandfather said, we want you to have this opportunity because there are some, there's some value in the education that you could receive in these schools. So I just say that so I want to see the religious liberty such that um, such that individuals' rights are protected and that they can attend the school that they wish to attend without being restricted from doing so.
Amen.
Well, with that sermon, I thank you so much. I'll get off my soapbox for now. And thank you so much, Monica. It was really a great pleasure talking to you about this. And I hope everyone else who listens to this session enjoys this as much as I did.
Yeah, thank you so much, Preston. This has been absolutely lovely.